Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. We're happy to hear argument in our first case, number 19-2115. Counsel, whenever you're ready.
Thank you, Your Honor. Pam Keenan appearing today on behalf of the petitioner, Ms. Gomez. We filed this appeal from an administrative decision by the Board of Immigration Appeals on the basis that the BIA, adopting the decision of the IJ, ignored compelling, uncontroverted evidence in the record and applied the wrong analysis when determining that Ms. Gomez had not suffered persecution because of her membership in one or more cognizable social groups, particularly her family membership and her social group comprised of highly educated professionals working in her home country of Guatemala. We also believe that the BIA and the IJ applied the wrong legal standard when considering Ms. Gomez's request for humanitarian asylum. And we also believe that the BIA and the IJ glossed over the question of whether relocation by Ms. Gomez in Guatemala was in fact feasible or reasonable, and whether the government in the country of Guatemala could in fact protect her from the persecution and or for purposes of CAT, whether or not they were blindly allowing such persecution to occur. So turning to her first question about the persecution that she had suffered and could reasonably expect to suffer, she testified and presented affidavit testimony to the IJ that she was repeatedly made the subject of death threats in connection with extortion attempts and recruitment attempts of her various family members. As this court has held, death threats are considered to be persecution, and her testimony was uncontroverted on that aspect, and so I think she established that she had clearly suffered past persecution. The testimony, the evidence that came in at her hearing was that her husband was recruited to work for the gangs, and when he refused, the gangs threatened to harm not only him but his family members, which of course would include Ms. Gomez. Then her brother was also recruited to work for the gangs, and when he refused, similarly, the gangs threatened not only harm to him but to his family members, which of course included Ms. Gomez. The testimony also...
Does the record, Counsel, this is Judge Motz. Does the record tell us how many family members, how many brothers and sisters she has?
My recollection, Your Honor, is that she has this one brother who in fact was killed, and she has two other siblings who still live in Guatemala. Her parents also live there.
And does she maintain that they have also been subject to persecution?
Yes, ma'am.
Not her parents, her others, not her parents, but her other siblings?
This one sibling, her brother, who was eventually killed by the gangs, she doesn't know if...
I was talking about the two. I thought you told me there were two sisters still living in Guatemala with the parents. Is that incorrect?
Yes, ma'am. As far as I know, they have not been targeted by the gangs.
So
This is Judge Floyd. What evidence did you present that the Zetas remain active in Guatemala so that the internal relocation would not be possible?
I'm sorry, Your Honor, you broke up at the first part of your question. Could you repeat that?
Sure. What evidence did you present that the Zetas remain active in Guatemala so that internal relocation would not be possible?
There was quite a lot of documentary evidence that we presented in the record from various sources, and I believe also the State Department reports indicated that the Zetas are an active gang influence in the country.
Well, you need more than that, don't you?
Well, we had the testimony from Ms. Gomez herself as to her personal experiences, and then we had very supporting affidavits, and then the documentary evidence that was admitted by the IJ, including those State Department reports.
Hello?
Shall I proceed? Did you have any other questions, or shall I proceed with my argument?
No. Don't worry. I'll let you know.
Okay.
But I thought Judge Keenan had a question. Judge Keenan, did you have a question?
No, thanks. Okay. Not yet.
Okay.
After her brother was threatened, and after her brother refused, and the gangs threatened both him and his family, she then found out from her father that the gangs were extorting her father for money, and when he could not pay, they also threatened to harm him and his family, which of course included Ms. Gomez. Ultimately, they did in fact kill her brother, and there's evidence of that in the record, his death certificate, the report, her testimony, some supporting family affidavits, that they did in fact kill her brother, and she was very concerned that she would be next in line. After she found out that her father was being extorted, she herself was approached by the gangs. They had connected her with her brother in a moped accident before her brother's death, and she was approached by the gangs and told that because she was a public school teacher, which made her a government employee, that they wanted her to run drugs for them, that she would be a very effective mule because she would not be suspected of drug activity because of her education and her government position as a teacher. And she refused, and based on that, then they began threatening her directly because of her refusal to work for them, death threats. So the BIA and the IJ both found that her membership in the family wasn't the basis on which the death threats were directed to her or why she was made the subject of death threats. But I think that that's the inappropriate analysis that they applied in finding that she didn't meet that standard. But for her being a member of the family, those death threats that were made to her husband and to her brother and to her father would not have included her. It was solely because of her membership in those family groups that she was made the subject of the death threats that resulted from her husband and her brother and her father refusing to concede to the demands of the gangs. I did have an opportunity to read the recent decision by the Fourth Circuit in the Hernandez-Cartagena case that was just issued a couple weeks ago, where this court discussed the fact that the threats can be made to a family's, to the applicant's family, and that the analysis isn't what the motivation was for the gang making those threats to the family member. It could be greed, it could be extortion, it could be a lot of things. But the appropriate analysis is to determine whether or not the death threats that included the applicant were made against the applicant solely because they were members of the family that was being extorted or being recruited to work for the gang. And I think that's exactly what happened here. But for her marriage, her familial relationship with her brother and her father, she would not have been made the subject of those death threats. The ones that were made directly to her as a school teacher and an employee were ones that were directed to her, but the fact that there were direct threats to her later doesn't wipe out the fact that she was made the subject of death threats previously solely because she had these family relationships. So we think that the BIA and the IJ ignored substantial evidence and applied the wrong analysis in finding that she didn't qualify for asylum based on prior persecution due solely to her membership in that family group.
Counsel, excuse me, this is Judge Keenan. So it's your position then that there can be more than one central reason?
Yes, ma'am.
Is that correct? For
yes,
the persecution? And that's really, it seems to me that's the linchpin of your argument, isn't it, here today?
Yes, ma'am. That she had the family group, but then she had the death threats to her directly. But there can be more than one central reason, and we believe that the uncontroverted evidence showed that.
Okay. I just want to make sure that you were relying on that principle and not something else. Thank you.
Yes, ma'am. We also argued that her position as a government employee and a teacher led to her being persecuted, that was the specific reason that she personally and not someone else was targeted by the gangs and threatened with death if she wouldn't run drugs for them. So we have another reason, but these reasons can be intermixed and intermingled and still get us to the same result. We also argued that her open resistance to these gangs was an imputed political opinion, and this was another reason why she was persecuted, why she individually, herself and not someone else, was persecuted and made the subject of these death threats. This court has previously held that a refusal to join the gangs or to work for the gangs has a political dimension, and gangs may target resistors for retaliation as part of that, and that's exactly what happened here. The death threats were made to her because she was openly opposing their efforts to recruit her. She went to the police and reported the persecution that her brother and her father and herself had been suffering. Of course, the persecution only increased after she went to the police. The gangs obviously knew she had done that. Shortly after reporting this to the police, her brother was kidnapped and tortured and his tongue cut and beat up, and then, of course, was eventually killed.
Counsel?
Yes, ma'am.
Counsel, this is Judge Motz. So as I remember it, the BIA, the judge, concluded that what the gang was after was money, and it really didn't matter. They didn't care who they got it from. And so what do you have to say about that?
I think that brings us back to the Hernandez-Cartagena decision, where this court discussed the fact that the motivation for what the gangs wanted is not the appropriate analysis for purposes of determining whether the applicant has suffered persecution in the form of death threats. It certainly, in that case...
No, Counsel. But it certainly is informative about why they are targeting the person. If they're targeting for money, that's very different than targeting because you're part of a family, right?
Well, that was our second basis for appeal. Her first one was that she received death threats with respect to her husband, brother, and father solely because she was a member of the family. They weren't targeting her for anything.
I know you say that, but there's a finding to the contrary, isn't there? And I guess what I'm asking is if several members, but not all members of a family, are targeted for financial reasons, does that mean you're targeting them because of their familiar ties automatically, or is it because of the financial reasons?
I think that the other members of her family were targeted for financial reasons. I think she was made the subject of death threats solely as a member of those family members who were not acquiescing to the gang's demands.
Well, Counsel, what about the fact... Counsel, this is Judge Keenan. What about the fact that the family witnessed a gang murder? I haven't heard you say anything about that today. Is that a significant fact in your analysis or not?
No, ma'am. That is simply the predicating factor that led to the gang starting to target her family members for working for them and for money.
Okay. Thank you.
I don't think I understood that answer. I thought you said no, but then the rest of your answer seemed to be yes.
No, ma'am. The witnessing of the murder at the very beginning of this whole timeline was how her family first was noticed by the gangs. And her shortly after that, her husband started receiving calls from gang members demanding that he come to work for them.
Yeah, I guess what I was interested in that fact was apparently that the gang told her family to forget what they saw or the gang would kill them, the family. Is that an accurate reading of the record, or could you help me there?
Yes, but not the basis of our appeal.
Okay.
Okay, I think my time is up.
What do you mean it's not the basis? Did you say it's not the basis of your appeal?
She did not claim that was a specific social group that she belonged to, and they were persecuted as a group who had witnessed a gang murder. That was not one of the social groups that she was resting her.
Yeah, but the principal social group, the number one social group, is her family. And this happened to a member of her family, right? So it seems to me it is part of your appeal. It's a fact that helps you a lot, I would think. Explain to me why I'm wrong here, because I must be misguided.
Well, I have to fess up to you. This is my very first immigration case ever, and so I'm very new to this area of law. But the cases that I read indicated that being a member of a group who had witnessed some sort of gang violence was not a cognizable social group that you would be able to claim you were a member of. It was too amorphous.
Right, but I think, Ms. Keenan, the underlying issue is it was her family that witnessed the murder and was told not to say anything or they would be killed, and you are saying she is being persecuted because of her membership in her family, and it seems to me there was
right. I see where you're going. I would say that would be an additional helpful factor for my argument that it's a family group that she belongs to. That's her social group, and that she's being persecuted as a member of that social group, that particular family relationship. Thank you. I understand what you're asking me. Thank you.
Any further questions? Okay, we'll be happy to hear from the government.
Okay, good afternoon. May I begin? Am I on?
I beg your pardon?
Oh?
Yes. We can hear you.
Okay, great. Please the court. Judge Motz, Judge Keenan, Judge Floyd, the government is sympathetic to people like Petitioner who are trying to escape crime and gang violence in their native countries. That said, for better or for worse, Congress has decided that our asylum laws can only apply to people who fulfill specific criteria. In this particular case, Petitioner's case, however unfortunate, the agency determined that she did not fulfill several of the elements required for asylum, and those conclusions are not only supported by substantial evidence, but we do not see any evidence that would compel reversal of the agency's decision here. With respect to the number of siblings that Petitioner had on page 169 of the administrative record, she actually said she has 2 sisters and 2 brothers, one of whom was killed. So that's 3 siblings, and there's, as far as the record is concerned, nobody has been bothered by the gangs other than the brother that was killed. So that, while the government would agree that that's not dispositive of the question, we do think that that's substantial evidence that tends to negate her claim that she's suffered persecution or has a well-founded fear of future persecution on the basis of her family membership. And in the court
so
says,
how many counsel?
Yeah.
This is Judge Motz. How many siblings would have to be killed before we would draw a line among them? One isn't enough. So.
That's a very good question, Judge Motz.
I don't think if I was the government, I would go down that road. I don't think that's your strongest road.
Okay. All right, of course, Judge Motz. All right. I would also say that with respect to the direct threats that she received from the gang, direct threats, not threats received from third parties, on page 244 of the administrative record, she admits the direct interactions that she had from the gangs had absolutely nothing to do with her family, her last name. It was entirely due to her employment and the fact that the gangs wanted her to sell drugs. So again, the only times that she was referenced in family membership was with respect to her husband, and again, that occurred in 2009. They witnessed the accident in 2008. Apparently, in 2009, her husband was told that if you didn't work for us, we will kill your family. They never contacted petitioner here, and her husband left for the United States in 2010. She did not hear anything from the gang again until 2015. So, the only remaining aspect of family membership is the extortion, where where families supposedly received extortion threats or their family members would be killed. But the gangs didn't mention that in their interactions with her. There's no evidence suggesting that the brother was killed, however unfortunate, because of this extortion. And again, I won't go down that road, sure. My greater point being that...
Excuse me, Mr. Stanton. Mr. Stanton, this is Judge Keenan. You said there was no other evidence tying back to the brother, but wasn't there evidence that Ms. Diaz de Gomez received a phone call saying they would do to me what they did to my brother? And she was later approached by the gang members when she was visiting her brother's grave. If they threatened to do to her what they did to her brother, why isn't this more evidence linking her to a particular social group of her family?
Well, she was visiting her brother's grave. At the time she visited her brother's grave, the gang truly didn't claim any credit for her murder at that time. They just said, if you don't join us, you will join your brother in the grave. They didn't mean they actually killed her. No one knows what happened to the brother. That there were no witnesses. He could very well have been he was at a restaurant. He could have been in the wrong place at the wrong time. So she received a phone call. The gangs may have been aware that the brother had been killed, but that doesn't compel the conclusion that they actually did it. So, again, she did not report the murder to police. Had she done so, there may have been an investigation concluding that these Zetas had actually killed the brother. But again, when her own testimony, she did not believe that her on page 244 that the threat she received directly from the gang had anything to do with the family relationship. That's her own opinion. So I don't see how the court could possibly reverse the agency's finding that there was no nexus on a family relationship based on that record.
Well, counsel, the agency found her credible, correct?
Sure. Yes.
So her testimony is credible. You just disclaimed it.
One second, please. The testimony. The testimony is credible. Doesn't mean that she may be telling that she may maybe not lying, but just because her testimony is credible doesn't mean that the agency has to accept everything she says is factually accurate. People may be testifying credibly, but the testimony may not be accurate for all types of reasons. Faulty memory, for example. So this issue is actually, I don't want to get off too far on track. This issue is actually up on the Supreme Court right now. The Ninth Circuit held recently that if the fact that the immigration deems the witness credible, then you have to accept even her opinions. that she's going to be killed in the future. But the greater point for now being, I'm not sure, my recollection, only the Ninth Circuit has gone that far, but just because an alien has been deemed credible, a non-citizen has been deemed credible, I mean, it doesn't mean that you have to accept the non-citizen's opinion that she faces persecution if returned to her native country. So, any other questions on that, or should I move on? I can't. So, hello.
Thank you. This is Judge Keenan. I'm done. Thanks, Mr. Stanton.
Mr. Stanton, this is Judge Floyd. Is there any authority that requires an applicant to actively attempt to internally relocate before seeking asylum?
Exactly, Jeff. The burden, Judge Floyd, is the burden is on the applicant for asylum to prove that relocation would be unreasonable. And all she did here was say, well, there's gangs everywhere. She relied on country conditions evidence, and the agency here held that's just not enough to meet that burden. So, unless there's some specific evidence showing why relocation would be unreasonable, then I guess the answer to your question is yes. Then the alien, non-citizen, must show that he or she actively tried to move. As one once said it, asylum is supposed to be an option of last resort for applicants, not the first.
So, is your answer the same, that if we found past persecution, would your answer still be the same?
Waiting for the translation. All right. Okay. If you found past persecution, then the burden shifts to the government to demonstrate that the presumption is that the applicant would have a well-founded fear of future persecution, and that the burden would be on the government to show that relocation is unreasonable. So the immigration judge definitively held that she did not suffer past persecution. The board's opinion is a little ambiguous. Our brief was a little on the conservative side, but if you ask me to for a definitive position on whether or not the applicant here suffered past persecution, our answer will be no, that the immigration judge was correct, and to the extent the board's decision can be making a ruling either way, that the board affirmed the immigration judge's finding. She received the death threats she received. Most of them were indirect, and in Cortez Mendez, the court certainly doubted the indirect death threats could be to constitute past persecution. And the authorities where she cites where the court has found death threats to constitute past persecution, they were much more severe. Hernandez-Avalos, for one. I mean, the gang actually put a gun to the mom's head and told her she had 24 hours to convince her son to join the gang, or else she would be killed. This type of menacing, immediate threat. Those are the types of authorities. Those are the types of actions where it might be appropriate to find that death threat constitutes persecution. But to the extent petitioner here is arguing that death threats are per se past persecution, the government does not agree with that at all.
Well, counsel, this is Judge Motz. I think there's pretty clear Fourth Circuit precedent that a death threat does constitute persecution. And it doesn't have to be a gun to the person's head.
Yeah, Mr. Stanton, we said that specifically in Hernandez-Avalos. We said death threats are evidence of past persecution.
Death threats are evidence of persecution. So do all death threats constitute persecution, though, even if they go on for a long time? I mean, the gang here had plenty of opportunity to carry out their death threats and chose not to do so. So common sense, suggests the death threats may not have been of severity to constitute past persecution. I mean,
okay, Mr. Stanton. I'm sorry. Excuse me, Judge Motz.
Go ahead, please.
Mr. Stanton, and thank you. Mr. Stanton, if we were to decide that there was a nexus between Diaz de Gomez's family ties and the past persecution, the threats that were made against her. Is there evidence in the record that would rebut this presumption that would then arise of well-founded fear of persecution? What evidence is there to rebut that?
There is indeed. Again, the fact that other family members have not been harmed. I mean, we discussed that earlier. There's also the fact there's not enough evidence that the authorities will be unwilling or unable to protect her from the gangs. It's obviously I would concede that the Guatemalan Police Department didn't distinguish themselves with respect to her one visit where she only talked about the threat. She didn't mention the extortion. She didn't mention her brother being killed. She didn't mention the murder she witnessed in 2008. She only talked about, hey, these gang members are bothering me at school. They want me to sell drugs. In a perfect world, the Guatemalan police would have given her case the urgency that that it merited. They chose not to do so. That being said, there's a lot of evidence in the record showing that Guatemalan police is actively trying to fight the gangs, and they've arrested gang members. They've battled gang members. In 2008, the Zetas, the gang members that murdered the other gang members, they told petitioner and her family, if you say anything to the authorities, we're going to kill you. I mean, common sense suggests the gang members were actually afraid of the police. So, and I think the court actually made the same point. Sedalia, if I'm pronouncing it correctly, case it's in our brief. So,
okay. I guess what I'm trying to figure out here, and maybe you can help me, Mr. Stanton, and this is Judge Keenan again. It seems to me if we have a shifting of the burden, if we disagree with you on the issue of family ties and past persecution being one central reason for her persecution, don't we have to vacate the other findings of the IJ and BIA and just send it back for a re-examination in light of the fact that we have found past persecution? It seems to me that it's really impossible for us to weigh evidence that was predicated on a finding that there wasn't past persecution, was not past persecution. You see what I'm saying?
Yes. So I would concede that if the court rules against us on nexus and also finds that it's inconclusive or rules against us on past persecution, then the agency's relocation determination would have to be reexamined, because then the burden, as I mentioned to Judge Floyd, I think it was Judge Floyd earlier, that the burden would then shift to the government. But with respect to the unable, unwilling, and the lack of harm to other siblings, I mean, that should be sufficient to uphold the finding that she does not have a well-founded fear of future persecution, Your Honor. Okay. And again, with respect to humanitarian asylum, unless there's any other questions on asylum, humanitarian asylum is pretty much tied to her statutory claim. Petitioner raises other serious harm, but she did not present that theory to the agency, and so she has not exhausted that particular theory. And with respect to the claim under Convention Against Torture, I'll make many of the same arguments that she hasn't shown relocation. I don't think the burden shifts on for CAT either. I'm not aware of any authority. The burden shifting will apply to asylum claims, and also again the evidence that the Guatemalan government is battling the gangs. So I know that it's a sympathetic case, and I can appreciate that some of the judges on the panel may have viewed the evidence differently if you were the immigration judges, but this court actually said an immigration case a couple of months ago after briefs were filed, but standards of review, they're like offensive linemen in football. I mean, they get overlooked. They may not get the glory, but they're really important, and they often determine whether a game is won or lost. There's an opinion by Judge Quattlebaum But I think that's the case here, that there's sufficient evidence, substantial evidence supporting the agency's denial of asylum and humanitarian asylum and CAT, and the record does not show that the evidence compels reversal. I forgot to mention that the imputed political opinion with respect to asylum. Again, the Supreme Court held in Elias Zachariah that unwanted forced recruitment is not persecution on account of a political opinion. So counsel said she cited some cases finding opposition to recruitment to constitute persecution. Those were all out-of-circuit decisions. That Jabril case, she miscited as a Fourth Circuit case. It's actually a Seventh Circuit case. And those also involve quasi-political organizations. One was about the formation of a group opposed to the formation of Israel. Others were political guerrillas. And that's just not this here. Gangs, they don't really have political aims. They just want crime and power, control, money. That's really all they want. So I would submit to you that it's unfortunate, but the agency reached the correct decision here. It should be upheld. If there are no other questions, I'm happy to rest on the briefs.
Thank you very much. Do we have any rebuttal?
Thank you, Your Honors. Very briefly, the briefs say everything that we need to say, but there is a point of context that I would like to point out. We've discussed this afternoon about relocation and whether it's reasonable or feasible for her to do it, whether she tried to do it. As I pointed out in my brief, the entire country of Guatemala is roughly the size of Mecklenburg County, which is where Charlotte, North Carolina sits. So when we're talking about internal relocation, and I think Mecklenburg County is probably roughly the size of the county in which the court sits, in Richmond. So when we're talking about internal relocation, we're talking about her going from one side of the county to the other side of the county. And we're talking about a country where our own State Department has, year after year after year, filed a report saying that gang activity is extensive, pervasive, intrusive, and largely has infiltrated the police. So, and are much more well-funded than the police. So I think it's easy for us maybe to sit in America and talk about internal relocation within the country as a means of avoiding harm, but that is a very different situation on the ground when we're talking about a country the size of Guatemala with the historic levels of gang activity both within the government and without. The one other thing I would point out is that I believe that there's simply the wrong legal standard applied to her request for humanitarian asylum. As I read the cases that I have researched, qualifying for statutory asylum is not a prerequisite to qualifying for humanitarian asylum. Those are different things, and I think that the IJ and the BIA adopted the IJ's conclusion that because she didn't qualify, they felt that she didn't qualify for statutory asylum, and that ended the question on humanitarian asylum, and I don't think that that's the state of the law. So thank you for your time today and your patience with me as I try to figure out my first immigration case.
Well, we appreciate your argument. Thank you very much.
Thank you.
The case is submitted. We'll ask the clerk to adjourn court.
The court will take a brief break before hearing the next case. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Good afternoon. We're happy to hear arguments in our second case number 197027.
Thank you, Your Honor. Thank you, Your Honor, and may it please the Court, Andrew Tutt for Appellant Thomas Heyer. I'm joined this afternoon by my colleague Ian Hoffman, who tried this case and also argued Heyer won. This is a case about whether BOP's prospective absolute ban on access to a video phone for Mr. Heyer, a deaf civil detainee in its custody, violates the First Amendment. The answer is yes. The record establishes that BOP's prospective absolute ban on any video phone access cannot withstand scrutiny under the four-factor test set forth in Matherly against Andrews that this court uses to determine whether a prison regulation unduly infringes on a constitutional right. We have two arguments. I will briefly describe our two arguments, then address each in more detail. First, Mr. Heyer has a First Amendment right to communicate with others beyond the prison walls. And the record establishes that though Mr. Heyer is well-versed in American Sign Language, he is illiterate in English, meaning only a video phone can accommodate his right to communicate with others beyond the prison walls. The record also establishes that BOP could accommodate this right at little cost and with de minimis risk. Second, and regardless, even if Mr. Heyer were fluent in English and email, letters, and the TTY device were effective means of communication for him, the BOP's policy would still violate the First Amendment because detainees have a First Amendment right of reasonable access to a telephone, regardless of their ability to use written methods of communication. For deaf individuals like Mr. Heyer, a video phone is the functional equivalent of a telephone, and denial of access impinges his First Amendment rights in the very same way. Turning to our first argument, BOP's prospective ban on access to a video phone fails Matherly because only access to a video phone can accommodate Mr. Heyer's First Amendment rights, and BOP could accommodate the right at little cost and de minimis risk. First, Mr. Heyer's inability to communicate effectively in written English means only a video phone can protect his First Amendment right to communicate with those outside the prison. Mr. Heyer is functionally illiterate in English, meaning he cannot use written means of communication like letters or emails or the TTY device as a means of communication outside the prison walls. As even the district court found, his ability to communicate in English is equal to that of a 7-year-old child. At best, Mr. Heyer has the English reading and writing ability of a child in the 3rd grade. That finding is conclusive that Mr. Heyer is incapable of effective communication in written English. For Mr. Heyer, yes.
Counsel, this is Judge Motz. Can I ask you how you have been communicating with Mr. Heyer?
Yes, Your Honor. We speak to Mr. Heyer via... Oh.
Not what you said, just the means.
So, are you asking, Mr. Heyer can call hearing individuals using a VRS system, which is provided by the FCC, and allows deaf individuals to make telephone calls to hearing people. And so he and I have translated calls, if that's what you're asking, but I might not have understood.
So this doesn't affect one way or the other relief he seeks here. Is that correct? Because he's now been given the ability to do that in response to our first opinion in this case. Is that right?
On the eve of trial, or on the eve even of judgment, my understanding is that BOP agreed to provide him access to the VRS system. And there are material differences between VRS and point-to-point video phone. But what VRS cannot provide Mr. Heyer is the ability to talk to any deaf individuals outside of the prison.
I understand that. But
yes,
isn't that the only thing? He requested a range of relief in the first lawsuit, right?
Yes, Your Honor.
And he has received much or maybe all of the relief except for that which is at issue here. Is that correct?
Yes, Your Honor. Yes, Your Honor. Yes. What is left is access. The question of access to communication with what's really the most important group of individuals for Mr. Heyer to communicate with outside the prison walls, which are other deaf individuals and his close family, because he would like the ability to also use the video phone to communicate with his brother George. And so we think that the VRS, though it looks like an attractive accommodation, is a little bit like telling an English speaker that they can only make telephone calls to non-English speakers. So we think that because it's not even only speak to English speakers through an intermediary, because VRS cannot be used to call another deaf individual. They are required to terminate the call. So he literally cannot talk to other deaf individuals. And yes, so all that was at issue at trial was that this question of point-to-point video phone access to speak to other deaf individuals outside the prison, and potentially his brother, with whom he used to use family signs and whom he would like to teach to sign. And returning to the point, he can't communicate effectively using written means. He can't use email. He can't use letters because he's not literate in English. And our second point is that BOP could accommodate.
Okay, excuse me, Mr. Tutt. Before you get to your second point, could you help us here by telling me what is the scope of this First Amendment protection? In other words, does he have a right to communicate with anyone outside the prison? Is that what you're saying his First Amendment right is? Because he certainly can communicate with many people outside the prison under the current VRS accommodation. So are you saying that under the First Amendment, he has to be able to communicate with everyone?
I am not saying he has to be able to communicate with everyone, but he should be able to communicate with individuals in the deaf community and his close family. I think the actual formulation of the communication outside the prison walls includes family as a specific instance of who prisoners should be able to contact. And with respect to deaf individuals, individuals who are non-hearing form a community of shared experience with whom conversations would be the most meaningful. They are the individuals Mr. Heyer would most like to contact. His close relationships, his last boyfriend, were deaf. The idea that it's not that he needs the ability to contact everyone, but he needs to at least the ability to contact those individuals for whom communication would be most meaningful. And so I think that would be the scope of the right. Although I will point out that when prisoners are granted reasonable access to telephones, it's though not an unrestricted right, with pre-clearance, they can often talk to pretty much anybody. So what turns on the scope of the right is not entirely clear. And I hope that answers the question. But we don't think he needs the ability to call the president and everyone else, just those people with whom it's the most meaningful communications. And he actually specified individuals in the record, named individuals he would like to contact and like to speak to, his brother, his former friends, those individuals. So individuals who are already close to him.
So counsel, this is Judge Motz. So your submission is that a claimant can make out a class of people to whom he has a First Amendment right to speak? Is that what your submission is? That's what it sounds like.
I think our submission is that this accommodation, and I apologize because it's probably not going to be the most even, but it's clear that at minimum he must have the ability to speak to other deaf individuals, he himself being deaf. It would be like telling an English language speaker that they can call anyone in the world as long as they don't speak English, or they could call anyone in the world as long as they don't live in the United States. We are not asking for a ruling that goes beyond pointing out that in this case, the ability to speak to his family and friends and other individuals who are deaf is at least sufficient to fall within the scope of the First Amendment right.
Okay, Mr. Tutt, would you talk about the TTY devices? Because we do know that this would provide Mr. Heyer with an alternative method, and I understand that not as many people use those devices as used to, but what does the record show regarding whether this is a viable alternative method that we would consider under the Matherly factors?
Yes, Your Honor. The issues with the TTY device are many. So let me just begin with the most basic, which is that it is a device that requires spelling. You have to spell words in English to communicate, or in a language, but the only other language that he can spell is English. And it isn't sufficient for him because he, as no one disputes, at best has a third grade ability to write and read in English, which is an incredibly low ability. It is really the functional equivalent of illiteracy. So he can't use the device for the basic reason that he still wouldn't be able to use text messaging, even if a very efficient and effective form of written communication were available. So that's what makes the TTY device inadequate at the threshold, is that it requires writing. But there is this other issue, which is that deaf speakers don't use TTY anymore. And we do have record evidence on this. I'd also point to the terrific amicus brief by the National Association of the Deaf. But it is simply not used as a method of communication anymore because it was an essentially analog text messaging developed as a technology before text messages and emails existed. So, and both sides of the communication had to have one of these devices to be able to communicate. Does that fully answer the question, or
yes, thank you.
Like to just yes, thank you, Your Honor. Just turning to the fact that
counsel. I'm sorry, this is Judge Motz again. So maybe you can also talk to me about, because the first Turner factor looks to whether there is a legitimate government interest here, a valid rational connection between the prison regulation and legitimate government interest. The district court found that there was, and there seems a fair amount of evidence in the records suggesting that maintaining internal security and protecting the public are legitimate government interests that are furthered here. So maybe you can address those for me?
Yes, Your Honor. We think that this court said that one could legitimately question the connection between the interests and the actual policy because it was tenuous, because it does appear tenuous, and we don't walk away from that. We're not questioning that protecting the public, protecting Mr. Heyer, and protecting the prison are all legitimate interests, even in the context of detainees. The issue is the connection, and the connection between completely banning Mr. Heyer from access to a phone, a video phone, and those interests is extremely attenuated. We don't think the court needs to resolve this case at factor 1, though, because we think that factors 2, 3, and 4 so overwhelmingly point in Mr. Heyer's favor that the court can just resolve it in much the same way it did Heyer 1. Take Heyer 1 and say Mr. Heyer could prove and say the record shows, and say that therefore he is entitled to a video phone. And we think that would be an appropriate way to march through the analysis. I do just want to very quickly talk about how readily this could be accommodated, but I don't want to speak over any questions. But
can I ask you just a follow-up question? I'm sorry, with respect to the second factor, and you say, well, I guess you're sort of conceding that there are legitimate government interests here. You argue about how connected they are, but we have findings by the district court, right? So if we go into the second factor, you told us before about, and you've told us several times that Mr. Heyer could not communicate effectively in writing. But the district court expressly discredited that testimony, did not believe it. You know, we're not the triers of fact here.
Yes, Your Honor. But I would point out, it seems very clear that the court found, as a matter of fact, that Mr. Heyer communicates at a third grade level. The court found that, as a matter of fact. Even our own witness, Dr. Coakley, a world-class linguist, said that he had tested Mr. Heyer as 8 months into the second grade. So there's not really a material dispute about how well he can communicate. But third grade level writing is not sufficient to protect or preserve a person's First Amendment rights. I mean, under this logic, all prisoners, and I apologize, I know my time is up, but if I could just finish this.
No, go ahead.
All prisoners could be restricted to sending and receiving mail written at a third grade level because it would not constitute an impingement on their First Amendment rights because they can effectively communicate at a third grade level. You know, a third grade level doesn't give you the ability to debate politics or talk about sports, relay old memories, talk about your hopes and dreams and future plans. It is individual sentences. It is chapter books, little, at best, thin picture books. The third grade reading level just is not enough to express a fully adult person's entire mental faculties. And so we think the third grade level is a fact, but effective communication is a matter of law, and the First Amendment is impinged when people are restricted to speaking at a third grade level. And I am out of time. So we do think that this could be adequately accommodated. We asked the court to look at that, and we respectfully ask the court to reverse.
All right. I'm happy to hear from the government.
Thank you, Your Honor. May it please the court, my name is Mallory Brooks-Doris, and I'm here today on behalf of the appellees in this case, United States Federal Bureau of Prisons. This is an attempt to retry the case that was properly heard and decided by the district court. The question presented today is narrow: whether the district court clearly erred when it found that the BOP did not violate Mr. Heyer's First Amendment rights in its decision not to provide him with access to point-to-point video phone technology. The government respectfully urges this panel to reject Heyer's invitation to act as fact finder again. We ask that you affirm, as it is clear that the district court did not err in its decision following the 2-day trial in 2017. This case is unique because Heyer is not a typical federal inmate. His current status and background are vital to the issue at hand and the Bureau's determination as to Mr. Heyer. As this court is aware, Mr. Heyer is a civilly committed individual within the custody of the Attorney General pursuant to 18 U.S.C. 4248. So in 2012, the Eastern District of North Carolina designated Mr. Heyer under the statute as a sexually dangerous person, also known as the Adam Walsh Child Protection and Safety Act. That determination as a sexually dangerous person was affirmed by this court, the Fourth Circuit, in 2014. Mr. Heyer has an extensive history of sexually deviant behavior against children, and the Bureau of Prisons made an individualized determination as to Mr. Heyer due to his disturbing background of sexual deviance as to not provide this specific technology to Mr. Heyer. And as you saw from the record, the Bureau of Prisons does provide a great deal of other accommodations for Mr. Heyer.
Counsel?
Yes, Your Honor.
This is Judge Motz. It's hard to get your attention. So on that point, what is the Bureau of Prisons policy on point-to-point video phone access in general?
Your Honor, the Bureau of
Prisons... Is there a policy, a blanket ban?
No, Your Honor. That is not the Bureau of Prisons policy, and it was not what was put forth to the district court when the district court heard this case. Instead, it was an individualized determination as to Mr. Heyer. And Mr. Craig, Todd Craig, who testified on behalf of the government at trial, as well as former Warden Manzacani, both expressed that as well, that it was a determination as to Mr. Heyer in this case and his background.
Because of his record, and is that what was help me with that? Is there evidence in this record that other people are given point-to-point video phone access?
There is, Your Honor, and I know that appellants put forth that evidence, and it was considered by the district court. I believe there was a pilot program during the testimony from Warden Manzacani. He was questioned on that as to the pilot program of point-to-point technology across the Bureau. I think the pilot program specifically for Warden Manzacani, when he was questioned, was a small population of inmates, at a female institution. So it is provided elsewhere within the Bureau, but this case in particular was an individualized determination as to Mr. Heyer.
Well, but your answers seem to contradict themselves, okay? So some women somewhere in some other prison get to have this point-to-point video phone access, but I gather no one at this prison does. Is that correct?
That's correct, Your Honor, and I would respectfully counter that and suggest that it actually weighs in favor of the Bureau that they look at the individual security risks in each case. So the pilot program but it sounds like the record suggests that they don't look at the individual security risk in each person's case, but they do it prison-wide. You just tell me what the record says about that. I would respectfully believe that the record shows that this was a determination as to Heyer and the Maryland unit. There was a lot of talk about the Maryland unit itself, where Mr. Heyer is housed, and it's the only location within the Bureau that houses sexually dangerous individuals pursuant to 4248. So that might be what you're referencing, but it's not a BOP-wide determination. I think that what you also might be referencing is some testimony by Mr. Craig to the district court, who mentions that they do look at other institutions and they have been looking at it in other locations. But again, it's individualized as to the security risk, which is essentially the question for the Bureau in every case. Is there a security risk as to this technology? And it's why Mr. Craig's office exists. Did that answer your
question? Individual means, to me, maybe individual is different to you, but individual means with respect to unindividual. And as I understand your answer, and I guess I thought from the record was, everybody that's in this unit, nobody is allowed this point-to-point video phone access. Is that correct? It is a blanket ban.
I would still argue respectfully that it is individualized, but you are correct in stating that nobody else in the Maryland unit has this technology, but simply might be for the fact that nobody else has asked for it or is deaf and potentially might need it. And so this was assessed as to Mr. Heyer because he is deaf and would potentially need and or has requested this point-to-point video phone technology. But you are correct, no one else in the Maryland unit has this technology.
But I thought your claim was... Go ahead, Judge.
Go ahead, I'm sorry. You finish up your line.
Go ahead.
I apologize, Your Honor. Would you like me to continue?
I thought Judge Floyd had a question.
I do. I'm sorry. My question to you, what's different about supervising a point-to-point call as opposed to the other method that he uses? What differences would there be?
What the district court heard at trial, which was from Mr. Craig and former Warden Manzacani, was that there is actually a great deal of difference. The technology that he has now that you all discussed with counsel is called a VRS, which has an interpreter. So Mr. Heyer signs to the interpreter, who then interprets into English to the other participant in the telephone call. So when this technology was assessed for Mr. Heyer, it was found that this could accommodate his First Amendment right while still having an intermediary individual, i.e. the interpreter, to ensure that the phone line and the system was not being abused by Mr. Heyer or the other participant of the call. So it was less of a security risk in the Bureau's determination than it would be to have direct access of the two individuals on the telephone call. Did that answer your question?
Yes.
Thank you. So I'll continue just to discuss briefly the standard of why we're here, and that's the clear error standard. And as I mentioned, the district court ruled on this in February after hearing a 2-day trial and determined that the First Amendment rights of Mr. Heyer were not violated by this specific ban. And again, this ban is just as to Mr. Heyer and the point-to-point video phone technology. And as you all are aware, the Supreme Court has held that there are two permissible or plausible views of the evidence, and it is the duty of the fact finder to weigh that evidence, and that's exactly what the district court did here. In its order, the district court, from JA 513 through 529, issued an opinion and discussed each of the Turner-Matherly factors. The overarching question that the district court determined was whether the policy was reasonably related to the legitimate penological interest as expressed by the Bureau, which I've mentioned is to protect, and as you mentioned, Your Honor, is to protect the public and the individuals in the institution from harm and danger. In the district court's order as to each factor, based upon the weight of the evidence and the testimony of each witness, the district court found that each factor weighed in favor of the government. In doing this, the district court is clear in its decision that it credited the testimony of the correctional experts, which we know from Turner are due some level of deference, but a fair amount of deference in making these types of security determinations. They explained that due to Heyer's extensive history of sexual deviance, they felt it was a threat to the public to allow him this access and that he could perpetuate forms of exploitation and criminal activity over this point-to-point video phone technology that simply isn't present in other forms of technology that they could potentially provide. The district court found that Heyer has access and is able to utilize the TTY, send and receive emails, write letters, have this, and call individuals using the VRS system that we've already discussed.
Counsel, what is the record evidence about whether Mr. Heyer can communicate effectively in writing?
That's a good question, Your Honor. So factor two, the record, as the district court explained in its opinion, there was obviously conflicting testimony on this point. Dr. Coakley did opine that written English was an ineffective means of communicating with Mr. Heyer, which was the expert for appellants at trial. However, the district court in its opinion explains how essentially the entirety of cross-examination called into question that ultimate conclusion by Dr. Coakley, and therefore that ultimate conclusion was not credited by the district court, as is in its ability as fact finder. Some of the ways in which just cross-examination showed Dr. Coakley's ultimate opinion was verifiably called into question. Dr. Coakley never worked in a prison. He didn't have training in corrections. He met with Mr. Heyer once in 2013 for an hour and a half, and he did not supplement his report prior to 2017, nor did he interview him again. So there was some gap of time in that. He did not review a random writing sample for Mr. Heyer. That's in JA 168 in the cross-examination of Dr. Coakley. He wasn't aware of the amount of letters or emails or other means in which Mr. Heyer was able to communicate with others. And he also confirmed that there were correspondences of Mr. Heyer in which he was able to speak to people on the outside. For example, his brother, he was able to effectively communicate with his brother, as well as Brenda, who he refers to as his adopted mother. So on the other end of the spectrum, the other testimony that the district court credited as to how Mr. Heyer can effectively communicate was the testimony of Andre Taylor, who's a correctional counselor in the Maryland unit. And again, that's the only unit that Mr. Heyer has lived in. And Mr. Taylor has been Mr. Heyer's correctional counselor since 2009 and had frequently interacted with Mr. Heyer. His testimony in the record that the district court heard was that he's able to recognize Mr. Heyer's handwriting, and he's always able to discern what Mr. Heyer is asking. It might sometimes not be perfectly written, or there might be some errors, but he testified that regardless of how it is written, his ability to make sure Heyer receives what he needs within the prison is uninhibited by his lack of proficiency in English.
What does the record show us with respect to Mr. Heyer's close family? Are others in the family also hearing impaired or deaf?
Your Honor, the record reflects that no other individual members of his family, I believe, are hearing impaired or deaf. The one individual that appellant counsel and the record show that Mr. Heyer wanted to communicate with is his brother, and the district court heard testimony from Mr. Heyer himself when he expressed that he is able to communicate through the VRS machine and through with his brother, who is not hearing impaired.
But they wanted to use family signs, is that correct?
That's correct, Your Honor. That is the reasoning in which Mr. Heyer put forth as to why he wanted to communicate through other means with his brother outside of the VRS that is provided by the Bureau of Prisons. So I'll just move back briefly to the findings by the district court. The district court went on to find not only were there other available means for Mr. Heyer to effectively communicate with those on the outside, which I heard the questions previously, Your Honor, that you posed, and the government's position would be that the First Amendment right is for Mr. Heyer to be able to communicate with the staff and others beyond the prison walls, which is a quote from the first hire that came up to the Fourth Circuit. And we believe he is effectively able to do that, and of course that is what the district court found following trial. The district court went on to find that the BOP, in order to implement this technology, it would need to undertake new interpreter contracts because the current ASL interpreters that come into FCC Butner, while they come in frequently for medical appointments and for any treatment needs that Mr. Heyer might have, there is no contract in place, or there was not at the time of trial, for Mr. Heyer to have an interpreter to monitor these phone calls. District court also found that the Bureau would need to navigate a complicated waiver approval process and would not just be an automatic approval, even though there is some technology already in place. It would still need to go through the approval process for the point-to-point technology, as well as delegate staff time and resources to monitoring these calls, which was something that the district court heard from Warden Manzacani would be a tremendous strain on BOP resources to monitor these calls and ensure safety of the public. Therefore, the district court ultimately determined that these were far more than just de minimis burdens upon the agency itself. So ultimately, the district court said that whatever infringement might take place as to Heyer's First Amendment rights was in valid relation to the correctional requirements explained by BOP personnel when they took the stand during the trial in 2017. Therefore, if the panel has no additional questions.
It doesn't sound like we do. Thank you, counsel.
Thank you. The appellee respectfully submits the judgment of the district court should be affirmed. Thank you.
Do we have rebuttal?
Yes, Your Honor. 5 minutes. Thank you. This is Andrew Tutt for appellant. I would just like to respond to a few things and make sure I address any questions from the court. I think most critically, I want to point out that this is not an individualized policy about Mr. Heyer. it is undisputed that the Bureau permits other Adam Walsh detainees to use the telephone. Mr. Heyer is the only person in that program who is not permitted to use the functional equivalent of a telephone. Even on their own terms, the supposed reasons for limiting his access are difficult to believe. Mr. Heyer had mail rejected nearly a decade ago, but they have not banned Mr. Heyer from receiving mail. And most importantly of all, Mr. Craig noted, and the district court found, that no BOP facility is using phone technology as a method of communication for male inmates, deaf inmates, or sex offenders. That's at JA 517, quoting or citing to pages JA 269 to 279 of his testimony. This was is an across-the-board ban. The only reason that they gave John T.C. Ye access is because a ALJ in the Department of Justice determined that restricting access for Mr. Ye was a violation of the Rehab Act. I would also like to point out that in that case, they said that because he had committed financial crimes that had in part employed a telephone, he presented an especially grievous security risk. So this idea that anyone who actually wants to use a telephone is an especially dangerous prisoner is a common theme in these cases.
Mr. Tudd, excuse me, this is Judge Keenan. Could you address the impact on prison resources and why the district court was clearly wrong in that? Not the security risk, but the fact that they would have to essentially hire somebody, or at least place them on contract, to implement a new policy for a single detainee. Why was the district court, clearly wrong in saying that this is a burden on the system?
Yes, Your Honor. And this is in the briefs, and I don't have the pages in the JAs right at hand, but it really goes to Warden Mansukani's cross-examination and Mr. Craig's. But the issue is that they already have someone sit with him as he uses the TTY device. And it is conceded in this case that rather than sitting with him while he uses the TTY device, that same individual could instead sit with him when he uses the video phone. And so the conclusion that someone new would need to...
But that person,
yes, Your Honor,
in the context that you're requesting, would have to be proficient in ASL, would they not, to monitor him?
They would not, for the following reason.
Okay.
With respect to every other foreign language in the BOP system, they monitor the conversations and then translate them after the fact. And this is detailed in Mr. Craig's testimony. So there are 60 languages across the tens of thousands of prisoners. And for many of them, they record the call and then take the recording and have it translated by a third-party service after the fact. And so our argument is that 1 + 1 = 2. Someone sits with him when he uses the phone to make sure that nothing is shown to him, no abuse is on the phone, so the visual aspect is monitored, and there's no cost to the prison because someone already sits with him when he uses TTY. And then the signing aspect is covered by the fact that they already provide translation services for Chinese speakers, Laotian speakers, Spanish speakers, German speakers, other foreign language individuals, and they don't believe that needs to be done in real time to address any security needs of the prison system. So how the district court has a sentence that flatly concludes that the person who sits with him must be able to sign, but their own witnesses at a trial, this would be the only language in the BOP system where you would need to be able to translate it in real time for it to be adequately dealt with. So the visual aspect of the person... Yes, Your Honor.
I'm sorry. I thought that the testimony was that his brother wanted some special language between the two of them, not something that we would find in Chinese or Spanish, but special language in addition to doing this point-to-point, communication. Is that incorrect?
Your Honor, it's not incorrect. I will point out that if that is actually a security risk, put it to one side. He also wants to teach his brother ASL. And that's also something he testifies to and is also in the record. So it might actually, without conceding anything, access restrictions that are reasonable because they can't discern what's being said, put to one side. But he also...
But how are they going to know that, counsel? Counsel, how are they going to know that if they don't do, as my colleague just suggested, monitor it at the time? They can't do that retroactively.
Yes, Your Honor. But it is the same concern that could arise between any two siblings who are speaking on the telephone. It's not a material distinction. You know, two siblings who speak a foreign language could also have a family language, and some do. And so that would present the
really
same
in this record. In this record, we have people that have family language that are allowed to have this kind of communication. Really? Maybe you can tell me where that is in this record.
Your Honor, I'm telling you, you are correct. That has not been developed in this record, but it wasn't developed because it wasn't sort of put as in issue as the reason for these restrictions. So, you know, we shot down everything that was put in front of us. And if that was put in front of us, we would take aim at it as well. At the end of the day, that is not the reason for the restriction on Mr. Heyer's ability to have video phone calls with his brother. And so remember that what we're dealing with is a First Amendment right, probably one of the most significant rights that he has. He's in communicative isolation as a deaf detainee in a prison that doesn't have many other deaf individuals detained there. He's losing his ability to speak in sign language, and he doesn't have the ability to have these meaningful conversations. And teaching his brother how to sign would be facilitative of him retaining his ability to sign. And so...
Mr. Tutt, excuse me, this is
yes,
Judge Keenan. Is there any evidence in the record as to what level, like what grade level he is capable of signing?
Yes.
In other words, is there evidence as to how proficient he is vis-a-vis the general population in terms of his ability to sign?
Yes, Your Honor.
What I'm trying to get at is to what degree is his ability to sign more proficient than his ability to read and write?
Yes, Your Honor. And Dr. Coakley testified to this. And Dr. Coakley testified that he had I can't remember the exact formulation. It's in Dr. Coakley's testimony. It's something like proficient. He can carry on narratives. He can relate past events. And to a limited extent, he can describe hypotheticals and future events.
Right. Was there anything in the record equating to age or grade level like we have with regard to his ability to read and speak English?
If I recall, it was only in the negative. I wish I remembered absolutely. Dr. Coakley said he does not have the proficiency in ASL of my doctoral students or college higher education students. But Dr. Coakley explicitly compares it to English and says that it is far more advanced than his English language skills. And remember, Dr. Coakley is literally one of the world's, or was before he passed away, a world-class linguist who was an expert on deaf linguistics. The district court rejected his testimony by just citing the entire cross-examination and just saying, I think that all of his opinions and methodology are flawed. And so, this court is as well positioned to read that cross-examination and decide for itself, because we have no basis by which to understand why this world-class linguist opinion was rejected, but the testimony of a lay prison official was accepted, evidence of effective communication. And I hope that's the best I could do on the record. Dr. Andrews also discusses his abilities in English versus signing, and recommends that he have certain sign language translation because of his more advanced abilities. And Dr. Andrews was the other expert linguist in the case. So just to wrap up, this case is the reason we need a judicial check on prison officials. BOP has placed Mr. Heyer in communicative isolation for decades without any good reason for doing so. His contacts with the outside world have fallen away. His ability even to speak the language he speaks the best, ASL, is disappearing. This court should hold that the First Amendment requires BOP to provide Mr. Heyer with reasonable access to a video phone.
Judge Floyd, I have a question. Would you be better off committing to the point that we should define Heyer's First Amendment interest as a right to communicate with the deaf community? Is that not his best First Amendment issue?
Yes, Your Honor. That is we think his core claim that that is the large group of individuals with whom he has the most essentially impossibility of contact. Put aside,
what does the record show with respect to the number of individuals in the deaf community with which he wished to communicate?
Mr. Heyer testified that he had 20 individuals that he would like to speak to. He named 3. It's true that George Heyer, his brother, is hearing, but his friends Dennis Harden and Jordan Pitts, which is at JA 242 and 243, where he talks about it's transcribed as Hicks, Hick, but it's actually Jordan Pitts, Pitts, who is his ex-boyfriend. Now he has struggled to stay in contact with them, and he hasn't spoken to them in a long time. But again, it's worth emphasizing that he's been in functionally communicative isolation because it's so extraordinarily difficult for him to actually communicate through the methods that are available to him. But he named those 2 individuals as people he'd like to speak to. And I want to point out the possibilities for Mr. Heyer if he obtains access to a video phone. There are individuals at the National Association of the Deaf who would love to speak to Mr. Heyer, who are not hearing, but are not able to speak to him because he can only communicate through VRS. He has hearing lawyers, in part because it facilitates communication because of VRS. So there are strong countervailing interests even beyond the people he was able to name explicitly. So thank you, Judge Floyd. And if there are no further questions, we would ask the court to reverse.
Thank you, counsel. The case is submitted. We'll ask our clerk to adjourn court for a few minutes, and then we'll go on to our next case.
The court will take a brief break before hearing the next case. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Good afternoon. We're happy to hear argument in number 1867. Sorry. Counsel, you can proceed.
Thank you, Your Honors, and may it please the Court. My name is Thomas Birch, and I supervise the appellate clinic at the University of Georgia, appointed by the Court to represent Mr. Palacios. Today, one of our 3L students, Molly Fierro, will present argument on her behalf, and I'll be standing by online. Thank you very much, Your Honors.
Thank you.
Your Honors, and may it please the Court. My name is Molly Fierro, and I represent Israel Palacios. Mr. Palacios was convicted of both a lesser-included firearm offense under 924C and a greater firearm offense under 924J. The government now concedes that these two counts were duplicative. So the question is whether Mr. Palacios' counsel was ineffective for failing to raise this double jeopardy objection at trial and on appeal. The district court found that he was not, stating that the law was unclear at the time. But this court should reverse that judgment for two reasons. First, at the time of trial, his double jeopardy claim was foreshadowed by the available case law and jury instructions. And second, Mr. Palacios was prejudiced by the imposition of an additional conviction, fine, and consecutive sentence. On the performance prong of U.S. v. Strickland, Mr. Palacios' trial counsel fell below the objective standard of reasonableness because they failed to object contemporaneously to the double jeopardy violation, to bring the issue to the court's attention, and to preserve it for appellate review. The standard for what claims had to be raised is one of foreshadowing. That's the standard that this court has articulated in both Morris and Carthorne as one that means that the arguments are not, even in the absence of decisive precedent, the arguments are sufficiently foreshadowed in existing case law. Even if it's unsettled, if there's relevant authority strongly suggesting that the argument should be made, then counsel was obligated to raise it. At the time of trial in 2008, there were several indicators that this argument was viable, the most basic being nearly 100 years of Supreme Court precedent dating back to Blockberger, indicating that the most simple iteration of double jeopardy is when there is a lesser and greater included offense, not requiring proof of any additional element. The jury instructions in this case made that explicit when it said, quote, you should not, count 18, which was 924J, is to be considered only if you first find the defendant guilty under count 17, which is 924C, as charged. That's JA at 106. And that instruction makes sense because the statute in this case, if you look at 924J, says, quote, a person who, in the course of a violation of C, causes the death of a person through use of a firearm. There are also several cases from the Fourth Circuit that foreshadowed this argument, the strongest of which being Robinson from 2001, which said that 924C violations are an underlying and necessary conduct element of 924J. There's also cases like U.S. v. Lufkin in 1991 when this court said, quote, the court must concern itself with whether the underlying crimes of violence supporting the Section 924C charges are duplicative under a double jeopardy analysis. Additionally, all of the circuit court cases who had decided this issue at the time had decided it in our favor, which suggests that if Mr. Palacios' counsel had done even preliminary research into this question, they would have raised this objection. Now,
well, excuse me though, Ms. Fierro, did you only have one circuit, the First Circuit, that had spoken on a related issue? And as also as part of my question, what I'm particularly concerned with is the Fourth Circuit decision of Drayton, because that really was contrary to the position you're taking today, isn't it? Because there we upheld both the convictions and sentencings in a 924C and a 924J, saying they were distinct convictions for purposes of sentencing. So how was this foreshadowed in the Fourth Circuit merely because there was a First Circuit case out there?
So I'll address your concerns about Drayton first. So the first is that Drayton addressed a different issue. It found that 924C and 924J were distinct offenses for sentencing purposes. And this particular type of double jeopardy claim was not raised. So even if there was an underlying or lurking in the record double jeopardy violation, the idea that the court in Drayton upheld both sentences doesn't mean that there was strong precedent against it. Second is that in Morris, this court said that the weight of the precedent, if it tilts decidedly in favor of objecting or not objecting, is the decision. And a single unpublished decision in Drayton, as compared to these other Fourth Circuit cases that were circling and lurking this issue, this exact same provision of the code, 924C, and whether or not 924J is a conduct element, would have substantially supported this position, and it would be bizarre and below competency standards for counsel to abandon this argument simply because...
So the lawyer, excuse me, Ms. Fierro, Judge Keenan again, so the lawyer in Drayton was ineffective for not raising double jeopardy? Is that what you're telling us?
Yes, Your Honor. Any attorney who had these cases available to them, which Drayton appears to based on at least the date of the appeal, that didn't raise a double jeopardy violation in 924C and 924J was ineffective in their position based on that standard in Blockberger and in the statutory language. But in this case, we also have the unique fact of the jury instructions, which made it very explicit that you can only consider 924J if the government proves 924C, which means definitionally that there was no additional element for 924C and that it was a lesser included offense.
Okay, what about the fact that counsel raised another double jeopardy claim? It was a different one, but why aren't we required to give some deference to strategic choices that counsel made? And if counsel thought he had a better double jeopardy argument, why was he required to raise both?
He was required to raise this argument because while there is often a presumption that we can explain away decisions of trial counsel based on trial strategy, those arguments are generally in the context of one more piece of evidence or one more witness that could sway or not sway a jury. Here, counsel was clearly comfortable raising double jeopardy objections to the judge, and we simply think that he should have looked over a little bit more what these charges were and raised a second one. But you know what? So what's concerning me here, Ms. Fierro, is you are setting such a high standard. You're relying on Robinson and saying that counsel should have read into Robinson the issue of double jeopardy. Robinson dealt with the venue provision, didn't it? There wasn't a specific double jeopardy claim in that case, and I'm just worried that what we're doing is maybe, or the argument you're making is what an extremely good lawyer would make, and that's not the standard that we apply here. I mean, Robinson didn't clearly forecast it. It was talking about venue, and aren't you asking us to really raise the bar or to lower the bar for what is ineffective assistance to counsel? The bar is that counsel is required to be aware of possible legal arguments that are foreshadowed in existing case law, even if the precise argument or issue has not been decided. And that's well made in both Carthorne and Morris. And so that is the standard that we're asking. We don't think it's anything above what this court has already decided. Robinson is about venue, but it considered venue insofar as to prove venue, you must prove what conduct elements were required. And in analyzing that, it found that 924C was a conduct element of 924J. So even if it viewed that in the context of venue, there was enough there that they should have been able to make the inference or seen the possibility for foreshadowing of this other argument, particularly given the statutory language and the jury instructions. The concern you raised about this other double jeopardy argument or the trial counsel's motion for multiplicative offenses is an important one because, as you pointed out, that was a different objection. So that objection was between whether the murder charges and the firearm offenses violated double jeopardy, whereas our argument is between the two firearm offenses. But even if that was the correct provision, counsel was still deficient because they never, the judge never ruled on that motion. They deferred it and said they would take it up at a later time, but the attorney never raised it again. So even if that was the right motion, it wasn't properly executed in any constitutional sense. The standard here is foreshadowing because we require counsel to be aware of the law at the time in order to make the most robust defense possible. And given the statutory language of the Supreme Court precedent, we think that that's established here.
Okay, thank you.
Ms. Fierro, this is Judge Floyd. Did the trial counsel testify during the 2255 proceeding?
They did not, Your Honor.
Okay.
Despite that, we think it would be appropriate for this court to vacate outright if you agree with our position in this case, because the facts themselves are undisputed. And this court can decide the question of prejudice, which the district court did not reach, without ever returning it to the district court, because essentially the facts are what they are and the law is what it is. We don't need further development.
Yeah, Ms. Fierro, excuse me, Judge Keenan again. What I'm concerned about is if we agree with your argument that there was ineffective assistance of counsel here, why wouldn't we have to vacate and remand for resentencing under the sentencing package doctrine, and maybe this would be a be careful what you wish for situation, because the end could end up worse under the sentencing package doctrine.
Right. I share that concern.
Mm-hmm. So it is, the judge in this case did structure the sentence in a way that was beneficial to Mr. Palacios, and it's not clear whether that was an intentional or accidental, but regardless of whether or not 924C is vacated, Mr. Palacios does not stand at this point to be released from prison. But this segues nicely into the prejudice issue, because our position is that the conviction itself, regardless of the way that the sentence is structured, is something that imbues prejudice. As the Supreme Court said in Rutledge, as long as, regardless of how much time an individual will spend in prison, the fact of an additional sentence, and then also in this case the additional $100 fine under 18 U.S.C. 3013, is something that as long as that's on the books, the prejudice prong will be met. We also have the Supreme Court case Ball, in which they acknowledge that there are adverse collateral consequences regardless of sentence structuring. So even if there was a new sentencing, we don't think, independent of that there would be any reason for a new trial. But even if there was new sentencing, it's our position that this sentence should be vacated regardless, because it only came about as a result of ineffective assistance of counsel at the trial court level.
Okay, thanks.
Certainly. And even setting aside everything else, just the jury instructions in this case that were actually in front of the trial counsel showed the double jeopardy violation by articulating that 924C was a lesser included offense of 924J by stating that no additional proof was necessary. Trial counsel should have understood that almost 100 years of Supreme Court precedent means that they should have made this objection. And we ask the court to find as such and vacate Mr. Palacios' conviction under 924C. Thank you, and if there are no further questions, I'd like to reserve the remainder of my time for rebuttal.
Thank you. Mr. Austin?
Good afternoon, Your Honors, and may it please the Court. Charles Austin for the United States of America. In August 2008, a jury convicted Mr. Palacios of various racketeering offenses, including RICO conspiracy, FICAR conspiracy, and murder, and the two charges under Title 18 of the United States Code, Section 924, at the heart of this ineffective assistance challenge. The charges arose from violent activities of the Langley Park Salvatruchas, a local MS-13 clique operated in Montgomery County, Maryland, co-founded by Mr. Palacios, including an October 2004 murder of a woman who was suspected of fraternizing with rival gang members. Almost 3 years after his conviction, the federal courts of appeal began addressing the discrete issue raised by the double jeopardy argument with respect to the interplay between sections 924C and 924J, where those charges arise from the same act. The government now asks the court to affirm the district court's denial of the 22-5 motion for relief, because as the district court explained, the cases addressing this particular issue and creating the still present split between the courts arose years after Mr. Palacios' trial and sentencing. Notwithstanding that counsel presented the very argument shortly before trial that is now pressed today, the blank canvas upon which these cases later drew demonstrates that the argument was novel, a long shot, or otherwise not sufficiently foreshadowed, that in failure to advance it falls beyond the wide range of effective assistance recognized by Strickland. If I may, Your Honor, I'd like to begin. Yes.
Judge Keenan, why doesn't the plain language of the statute raise the double jeopardy issue such that counsel, I mean, why are we, it seems to me that you can argue whether a particular case or another foreshadowed things, but what about the plain language of the statute? Why doesn't that telegraph the double jeopardy claim?
Well, Your Honors, I believe it doesn't telegraph it because of the nature of the inquiry here, and I believe I recognize where Your Honor is going with the question in terms of whether the punishments can be cumulative. I'd like to start by saying the government does not argue that the lesser included nature of 924C is something that was not foreshadowed, that was plain. That's actually how it was charged. What is the more novel piece of the double jeopardy argument, at least at the time of trial and sentencing, would have been whether under Missouri v. Hunter, Congress had authorized multiple punishments. Taking to Your Honor's question about whether the plain language doesn't control, the government believes that the state of the law at the time introduced some uncertainty. As Your Honor raised during my colleague's argument, there was the Drayton case, which, while unpublished, may have caused some concern about whether these counts could lead to successive punishments. There were the discussions in the 8th and 10th Circuits in Battle and Allen that examined whether these crimes were even discrete and separate crimes. Given the consecutive mandate of 924C, some ambiguity as to whether the crimes were discrete or not, there would have been reason to be uncertain as to whether the Hunter aspect of the double jeopardy challenge would have been one that was sufficiently strong enough to raise at the time of trial. So I believe that adds to that uncertainty, even in light of what the language of the statute read at the time. Turning to the point that Judge Keenan raised during argument, the claim was actually pressed that there was double jeopardy concerns here, that under Blockberger, the 924C and 924J counts could have led to a double jeopardy problem. The government disagrees with Mr. Palacios' current reading, which is that motion to dismiss multiplicitous counts was between the 924 counts and the underlying murder charges, not the counts themselves. Looking at JA 97, the motion stated that either of count 18 or 19 can be proven entirely through the evidence necessary to establish the other 3 counts pertaining to the murder of Nancy Diaz. Also, as raised in the reply brief and cited in the supplemental appendix, when the parties raised this before the court and had argument before jury voir dire on the day of trial, counsel was asked by the court, what would you like me to do? What would you like me to have the government do? And counsel responded that the government should have to choose between, and he misstated the numbers, I believe we clarified that in the briefing, but he essentially asked the court to make the government choose between the 924C and 924J. We think that makes it clear that counsel was actually raising the very issue that is brought up now, albeit without addressing the Hunter aspect that we raise now. They were certainly aware of the possibility of the double jeopardy analysis. And as Judge Keenan raised...
Mr. Austin,
yes.
Does Hunter require a defendant to show a lack of congressional intent as to double jeopardy issues?
I do not understand Hunter to require a showing of a lack of intent, no. If you're asking if they are required to show a negative, I don't believe so. I believe it's actually that they have to show that Congress explicitly intended it.
All right.
And Yes, Your Honor. I'm sorry. I didn't mean to cut you off.
No, you didn't.
Oh, I'm sorry.
Okay,
I thought I heard something.
if I could jump in again, Judge Keenan here.
Sure.
Mr. Austin, are you agreeing now that the 120-month 924C sentence was the only consecutive sentence? Because there seemed to be some confusion in your brief.
Yes.
Regarding the 120-month sentence in the conspiracy to commit murder in aid of racketeering. Are you agreeing now that the 120-month 924C sentence was the only consecutive sentence?
Yes, I believe that was an error in the brief, and in checking the judgment that's in the joint appendix, it does appear that all counts of convictions were in concurrent except for the 924C 120 months. I do agree, Your Honor.
Okay, thank you.
Yes. I would also like to note, with respect to the argument that was actually made, again, echoing Judge Keenan's concerns, the standard that's now being asked seems to be a pretty substantial one on defense counsel. It almost seems that they would be penalized for being too broad yet not specific enough. The government believes that the argument that was raised actually strikes the right balance to highlight for the court what the issues are. In fact, counsel even used the words fungible when referring to the 924C counts, without being so specific as to box themselves in at a later point in time and then be found ineffective assistance for example, asking that the wrong count be dismissed. We actually think that Strickland affords counsel this deference to make the argument that was made, and also, as Your Honor raised, to decide strategically where to focus their efforts, whether it be in post-trial motion or upon appeal. Turning briefly again to the unsettled state of the law, Judge Keenan had raised the question about whether at the time of trial only the First Circuit had spoken to the issue. The government's view is that at the time of trial, the First Circuit had certainly spoken to the lesser included aspect of it. However, this narrow question of whether 924C and 924J counts could sustain multiple punishments in the same indictment from the same offense was not addressed by any circuit court, to the government's knowledge, not by any district court, until February of 2011, which would have been approximately a few weeks after Mr. Palacios' direct appeal was briefed before the court. The opening brief was filed, I should say. So we're looking at about 2.5 years after trial that this was decided. And when it was decided by the 11th Circuit in Julian, it actually came out against the position that Mr. Palacios presses. And Julian found that there could be multiple punishments, but there was no double jeopardy issue. And then later, the First Circuit in Garcia-Ortiz, 4 days before briefing completed on Mr. Palacios' direct appeal, then found the position that Mr. Palacios presses today, and that a number of circuits have found later. So we think that shows, A, that the state of the law was certainly unsettled by the time of sentencing, that the state of the law continued to be unsettled with a 1-to-1 split at the time that the direct appeal was resolved, and continued to be unsettled. By example, I point to the Fifth Circuit's case in Gonzalez, which was decided in 2015. There, the district court actually sided with Julian, even though courts, in addition to the First Circuit, had adopted the view that there was a double jeopardy issue. And the government believes it would be difficult to fault the district court and trial counsel for not pressing this issue when no courts had spoken on it, when the reality is that even when some courts had spoken on it, there were still some disagreements about whether these consecutive punishments could be imposed. If I may move to the... yes.
This is Judge Motz. I have two questions for you. And the first one follows right up upon what you just said. So if this case came up to us with a trial that took place 3 months ago, the government would confess, and the result would be the same. The government would confess error because the law has been developed. Is that correct? That, as I understand, is what the government's done in other cases. So I would assume the United States of America would adopt the same position.
I'm sorry, Your Honor.
We're not there now.
I understand. I just want to understand the question. You're saying if we were if we were hearing a case that was decided a few months ago, I apologize. I may have missed something.
Yes. If we had before us appeal from a case that was decided a few months ago, so there's this development in the law, the government would concede that there was error. Is that correct? And it's what I understand the government has done in other cases.
I think that's correct, Your Honor. The law is more developed. Again, assuming Your Honor saying 3 months ago from now, the law is more developed now, certainly. The position is that in 2008, there was no one who had spoken on it. Yes. Yes.
Well, I understand your position. I just wanted to understand what the position was as it was right now. Okay, so my second question goes to your portion of your brief at the very end where you talk about remedy. And I don't know if you have your brief in front of you.
I do,
Signed document. Yeah. And you say that even you make the argument that there's no prejudice. But, of course, there's Supreme Court law that just this $100 special assessment is sufficient prejudice. So assuming that that's right, then you say that the only remedy that could be given would be to vacate the 924C conviction. And if we should hold that there was sufficient prejudice, that's what we should do. Does that continue to be the government's position?
I generally speaking, yes. If I may just add a little bit of qualification in preparing, the view of the government is that it would go back to vacate the 924C if the court finds that there was error under the first prong of Strickland, and the conviction would remain as to the greater offense. However, I believe that under Brand, the district court would actually be required to move that life sentence that runs consecutive to the RICO and Vicar counts and make that run consecutive. So actually, instead of it being...
But that's not what the government... But I hear you. I understand what you're saying Brand does, but that's not what the government said in its brief, did it?
I understand, Your Honor.
Late-breaking developments.
It may not be so much a late-breaking development, but a clarification that I wanted to make sure I understood what the law requires. I understood what I submitted to the court at the time, and in reviewing Brand, it has become clear that actually the court has adopted the view that the mandate requires it to run consecutive, and I only modify what I am saying now to the court in the interest of maintaining consistency with the court's precedent. I do recognize that.
But of course, if the government didn't insist on that, that wouldn't happen, would it?
I'm sorry, Your Honor. If the government didn't insist...
If the government didn't insist on an application of Brand, which it looked like from your brief, the government wasn't.
We were not, Your Honor. We did not at the time. I'm only trying to be careful because I don't want to insist that the government is agreeing to something that's contrary to Fourth Circuit precedent. I understand that it was not argued that it should run consecutive, and I don't believe that Mr. Palacios was arguing that it should run consecutive, although I do think that my colleagues representing Mr. Palacios agree that it was the point that the government raised in the district court briefing on this matter, but I do acknowledge that the brief that I submitted to the court does not say that so plainly.
Okay, I'm not exactly sure. It seemed to me that this brief gave me indication that the government was not going to rely on Brand if this case was sent back, that the only thing that would happen would be to vacate the 924C conviction.
Yes, that is how it's written. I suppose I'm confessing that I made an error in writing it because it's an inconsistent position with not only the law but the position that was advanced before the district court, and I'm just trying to be cautious of asking the court to do something that goes against it, against, frankly, the statutory requirement advanced by the court. I apologize if my answer is confusing. I just don't want to be seen as asking to do something.
I just want to know what the government's position would be if we did exactly what you said in the brief.
As I stand here now, Your Honor, I believe that under the law, as interpreted by Brand, the 924J count would have to run consecutive because of the way that 924C is structured. I do understand that is not what was written in the brief, but I believe that the law requires that outcome, even if my written advocacy did not recognize that.
Okay, thanks for your answer. And those are all the only two questions I had.
Thank you, Your Honor. Just briefly touching on the argument regarding appellate counsel, I would emphasize that appellate counsel offered wider latitude than trial counsel. We believe that there would have been no error raising it on direct appeal for the same reason there was no error raising it at the trial level, again, to the extent that it was not raised, which the government believes that it was. And turning to the prejudice issue, the one note is that the government believes that because performance was not deficient and the law was unsettled, that the court should not even reach the issue of whether the special assessment creates prejudice because there was no deficient performance under Strickland. Unless the court has any additional questions, I will rest on my brief for everything else, and I thank the court for its time.
Thank you. So do we have any rebuttal? Counsel?
Yes, thank you, Your Honors. First, I'd like to address the idea that this should have been raised on direct appeal. It would have been very difficult for Mr. Palacios' appellate counsel to do so, given that it wasn't raised before the district court. And that's when the strategic decision seems reasonable that they wouldn't have spent brief pages and time raising something that wasn't argued. So the fault really rests primarily with the trial counsel, and it's not something that is decisive whether appellate counsel was wrong in raising it or not raising it, because that's really where the issue begins. I'd also like to respond to the contention that the lower court motion actually did address the same issue we're dealing with here today, and to refer you to the trial counsel's argument, which was in our supplemental appendix at page 9. Trial counsel in this case said, quote, once the government, assuming it proves up the conspiracy to commit murder and the murder of Nancy Diaz, that threshold of evidence will enable it to prove up either use and carrying of a firearm or murder resulting from the use and carrying of a firearm. So that's how we can tell that trial counsel themselves believed that they were making an argument between the murder charges and the firearm charges, not within those two firearm charges. Additionally, the standard here is not uncertainty about whether this argument was viable or not. The standard is foreshadowing. And to fall back on the idea that it was a strategic choice is difficult when ignorance of the law, as this court has said in Morris, is not a form of strategic choice, and that's not a shield that we can use in hindsight to explain away ineffective assistance. Finally, I'd like to identify that before 2008, there were 3 circuits that had made and agreed with our position, being the 1st, 8th, and 10th. And the later opinion from the 5th Circuit in Gonzalez referred to those 8th and 10th Circuit opinions in Battle and Allen to agree with the principle that this would violate double jeopardy.
Counsel, can I ask you a question here? And I've appreciated your argument, and you've done a fine job, particularly for someone. You're still in law school, is that correct?
Yes, Your Honor.
In United States versus Brand, the court held that a sentence imposed for a violation of 924J must run concurrently to other sentences because Congress intended that punishment imposed for a 924J violation be subject to the consecutive sentence mandate of 924C. So I think there's a pretty strong argument that if we should vacate the 924C sentence or send it back to the district court to vacate, then the 924J sentence would be consecutive. And I really wonder if your client wants that result. You remember earlier in response to Judge Keenan's questions, she said you might have a total resentencing and get a worse sentence. This looks like the statute would require it, or our interpretation of the statute, in any event. Now, I know this is coming to you a little cold. I don't think the government quite made this argument in its brief. And so maybe you want to look at this case and then write us a letter about whether you might want to withdraw the appeal or not. How would that be? Or I'm happy to get your answer now if you have one.
At this time, we would not like to withdraw the appeal. It's our understanding that in vacating just the 924C conviction, that this court could discretionarily do that without subjecting this to an entirely new sentencing process.
Yeah, but are you familiar with United States versus Brand?
I'm not, Your Honor.
Okay, let me give you the site and let you all think about it. 776 F 3rd 276, 4th Circuit, 2015.
Thank you, Your Honor. I have that.
And we will be interested in, and let us say within 10 days, you give us whatever response you have. And if you want to continue the appeal, fine. I just want to be sure that you understand what Brand says. Okay?
Thank you, Your Honor, and I appreciate your concern.
Were you about to finish your rebuttal?
Yes, Your Honor.
Okay.
At this time,
Thank you very much.
Thank you.
The case is submitted. We'll ask our clerk to adjourn court, and then we'll go to our last case.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Good afternoon. Mr. Hawkins, we're happy to hear from you.
Thank you very much, Your Honor. May it please the Court, I am Richard Hawkins. I am here on behalf of the appellant, Sheila Holmes, and we are here appealing the District Court's decision granting summary judgment to the appellee on her ADA claim. I'd like to begin by thanking the Court for granting oral argument, and in particular granting it telephonically. I have a face made for radio, and so I certainly appreciate appearing in this manner. All kidding aside, Your Honors, we are here appealing an ADA claim judgment, and there are three issues that are before the Court on appeal. The first two issues are essentially mirror images of each other, and that is whether or not genuine issues of material fact exist as to whether or not a steel-toe shoe requirement is an essential function for Ms. Holmes' job. And then at the same time, the second issue is whether or not genuine issues of material fact exist as to whether or not a reasonable accommodation is available to Ms. Holmes to exclude her or to exempt her from wearing steel-toe shoes in her job. And then the third issue, more of a procedural point, but nevertheless important, which is whether or not the District Court abused its discretion in striking the declaration of Arlene Bland as part of the summary judgment record. Now, before I go through all of the points I want to get into as to those issues, I want to emphasize to the Court what this case is not, and what the facts of this case do not show. They do not show that between 2002 and 2013, which are the relevant time frames here, the 2002 is when General Dynamics took over the facility with Ms. Holmes, and 2013 is when they told Ms. Holmes for the first time that she could not be exempt from the steel-toe shoe requirement. I want to emphasize that in that time frame, there were no new laws enacted. There were no certifications created. There were no regulations promulgated that created for General Dynamics or anyone else in this facility a previously unknown safety requirement or legal obligation. The law that's in place is OSHA. It was enacted in 1970. The CFR regulation that was in place here and that's governing the PPE was 1974. The record reflects that there are certain kinds of private certifications. There is what's called the ISO 14001, which is a voluntary environmental regulation. The record doesn't reflect this, but you can take judicial notice to know that that regulation came into effect in 1996, well before the time period in question. And the same is true for what the record calls an OHSAS 18001, which is a British regulation that came into place in 1999. And the same is also true for company rules and company procedures. The 30B6 representative for General Dynamics at JA 293 testified that even as far back as 1998 and continuously, without exception, all the way through that time period, General Dynamics had always had a steel-toe shoe safety policy requirement. And so it's important to emphasize that at least contextually, there's nothing outside, there's no outside forces, there's nothing independent of the workplace itself that caused any obligations to be created that didn't already otherwise exist in this time frame. I think the record reflects also, undisputedly, that in this same time frame, Ms. Holmes, she never had this function essential to her. The record reflects, of course, that Ms. Holmes suffers from a brachymetatarsia. Say that fast 3 times, which is a congenital deformity or a congenital disease that caused her to have deformed feet and cause ulcerations on her toes when she wears these steel-toe shoes or when she tried to wear these steel-toe shoes. And she also suffers from diabetes, which causes her circulation problems. And I think kind of the best example or best evidence of what kinds of problems that Ms. Holmes faces with these conditions is when she testified in her deposition about this. And this is at JA 84, 85, 86, and 87. And in those pages, she said, "I'm a diabetic. I will not have sores on my feet because it can cause me to have my foot removed. I had previously had this brachymetatarsis when diabetes got diagnosis in her very, I think, casual and telling words, she said it put another tinker into it. You cannot have sores, you cannot have blisters or open wounds or anything. You will lose your feet. And those facts are undisputed. And it is against the record, against that background, that we have a competing narrative. We have, on the one hand, issues of safety compliance and policies and rules, and on the other hand, you have an unbroken period of 11 years where Ms. Holmes did not wear, or was not required to wear, these so-called safety shoes. And so on these facts and on this record, a jury could reasonably conclude at least one of two things favorable to Ms. Holmes. The first is that if there was a safety policy at General Dynamics, it was safety in name only. It wasn't on the ground. It's sort of a de facto versus a de jure policy. They say it on the one hand in writing, but when it gets down to the people on the ground, that's not how it's applied. Or, and this is just as reasonable, there's a safety policy at General Dynamics, but it is flexible for people such as Ms. Holmes, who have a medically justifiable basis for not having to comply with this particular policy. And we believe the district court erred in failing to recognize that the record evidence allowed for this conclusion. And in fact, we believe the record reflects that the district court, who is a fantastic district court judge, and I have the greatest of respect for him, but we believe the district court engaged in improper weighing of the facts as well as speculation about facts that weren't even in the record. And I point the court to JA 571, which is part of the district court's opinion, where the district court talks about the undisputed facts show that General Dynamics had legitimate business reasons for requiring Holmes to wear safety shoes. Exempting her from this requirement could have jeopardized its certification and standing in various organizations and agencies, and the record doesn't reflect that. The record reflects that for those persons for whom there was no medical justification, for whom wearing steel-toed shoes was an inconvenience, then that might have jeopardized a certification, but not as to the situation at bar. Yes,
Mr. Hawkins, this is Judge Keenan. I'm concerned about how we would write an opinion in your favor in this case, because wouldn't we be required to say that an employer must allow an employee to continue a job that creates a safety risk for that employee? In other words, you seem to be suggesting there's an estoppel principle at work here, that just because General Dynamics did nothing for 11 years, it can't do something now. And I'm very concerned that with regard to safety, I don't see how we can say in the context of an ADA claim that an employer is required to allow an unsafe practice if that unsafe practice is required for the employee to maintain their job.
Your Honor, that's an excellent question, and that is the headwind that I've been against the entire time in this case, and I think it is extremely valid to ask and to focus on that. My response is that when talking about safety, when talking about an employer's decision to say, all right, this is our policy, in this context, and I would ask the court in focusing on that question to look at the unique factual context that's before this court on this record. It isn't just that there's an 11-year record of one behavior and then a switch. It's it's what that 11-year behavior signifies. It's what it is properly inferred based on that 11-year behavior. It can't be that safety is such an important or overriding concern as to this requirement if it hasn't been enforced or hasn't been allowed to be enforced as to Ms. Holmes under these conditions. And I point the court as well to the regulations or the interpretive guidance on OSHA that we provided, which allow for a balancing of safety considerations, safety of the employee versus safety issues for the company, and say that requiring PPE to be worn is not a hard and fast rule where the wearing of that PPE would in fact create a hazard for the employee. And that regulation, it doesn't on all fours with this case address that issue, but what it does do is it shows that it is not a situation where this court has to choose between blessing an unsafe practice or saying that something is an unsafe practice versus saying that something is an accommodation or something is an essential function. It's our position that any concerns about safety have already been reduced, if not eliminated, by the court's or by General Dynamics behavior over an 11-year period. And what I would say,
Mr. Hawkins.
Yes, ma'am.
Mr. Hawkins, this is Judge Mott. So I appreciate your argument because it looked in your brief as if you were eschewing all safety standards. But is this a correct statement of your argument, that your client has set forth an ADA claim because she has alleged facts supporting her contention that with reasonable accommodation she could perform the essential functions of her job while complying with the employer's genuine safety requirements?
That is our position.
Is that
yes.
your contention? Okay.
It is our contention.
That's what I wanted to clarify.
And I apologize if my brief was a little bit too focused on Ms. Holmes versus safety considerations. I don't discount those, and I certainly don't underemphasize those. But I do think that in this particular fact situation, arguments about safety and arguments about compliance of certifications and those sorts of things are best stated to the jury, particularly because the record reflects that despite saying these things were so important, the company did not even call OSHA or did not even inquire as to whether or not there were any kind of I won't say escape valves, but I'll say ways to accommodate Ms. Holmes under these circumstances. And I do think it's important to emphasize that she worked for 11 years without concerns about safety. And it's not an estoppel issue per se, but what it does show, at least in our opinion, is that it does show that there is a genuine dispute of fact as to whether or not this safety rule really does apply in this particular context. What we are not saying, and I want to be very clear about this, we are not saying that General Dynamics has no obligation to enforce safety rules, and we are not saying that anyone and everyone who has ever, quote, gotten away with or been able to hide the fact that they were not wearing safety shoes is now somehow free and clear. That is not what we are saying. We are saying this is a situation where Ms. Holmes, and I do think the record is clear on this, she wasn't simply trying to disguise the fact that she wasn't wearing safety shoes. For many years, what happened is somebody would come around and they would say, do you have to wear your safety shoes? And she would show her doctor's note. And that is a perfectly reasonable thing to do under these circumstances. And we invite the court to review the case we cited in our Rule 28J letter, the Kataska case, which says that if an employee has performed a job for several years without having to perform that essential function and has been successful, then it doesn't really look like an essential function. And I realize that we have the nuance of safety, and that is kind of the overlay here. But I don't think that rule is any different. I think that rule is consistent with this court's opinion in Jacobs, and I think it's consistent with the CFR regulations that refer to the past practices of the incumbent employee when asking whether or not something is or is not an essential function. So we understand that there have been some, quote, areas of lax enforcement, but those situations don't change what we're saying here, at least on this particular record.
Mr. Hawkins, this is Judge Keenan again.
Yes, ma'am.
I think there has been at least possibly some confusion as to whether we're dealing with an essential job function here or a qualification standard to perform the job. And if this is a qualification standard rather than an essential function, what impact, if any, does that have on our review of the case?
Well, to me, that makes it even easier because she's qualified for the job.
No, but a standard. In other words, you can't do the job unless you wear the shoes, as opposed to wearing the shoes being a function of the job. Is there a difference in the analysis there or not?
Well, I don't think there's any doubt. I mean, and factually it's true. I think you can perform the job without wearing the shoe. That's the extra concern is that of safety. It isn't one of those things that you have to be able to do. Like it's not a lifting of a heavy drill or the lifting of heavy items for purposes of your job.
So it's not a job function then.
Well, that's
Rather,
what we contend.
It's a safety standard.
Correct.
As opposed to a job function.
That is correct, and as we've said, we believe that we are compliant with that. I will also say, or that it's a reasonable jury to conclude that we're compliant with that. The last thing I'll say on this particular point before I leave for rebuttal is that this is not a direct evidence case, at least not at this time on this record, nor is it a business necessity case. This is a simple qualification. Do we meet the basic threshold elements for the ADA? And so in talking about things like direct threats or safety, those are the burden of the defendant, the appellee, and those can be addressed, if at all, later down the road at trial. So we ask that the district court's decision be reversed, and we ask that the court recognize the genuine issues of material fact exist. Thank you.
Okay, we're happy to hear from the other side.
Yeah, good afternoon, Your Honors. May it please the Court, Mike Murphy here on behalf of General Dynamics. Let me just begin by taking issue with a comment the opposing counsel just made, that there's a nuance of safety at issue, only a nuance in this case. Tennis shoes are not a reasonable accommodation for the workplace hazards that Ms. Holmes faced in the shelter production area of the plant. As the record describes, this production area contains equipment, drills, which would have bits on them, as well as the materials themselves that could crush a person's foot. That, in fact, is not in dispute. Ms. Holmes' lawyer before the trial judge at Joint Appendix 539 admitted that there were these kinds of workplace hazards in the shelter fabrication area in the plant. It's not reasonable to have an employee working in that area in tennis shoes. In fact, the compliance with this OSHA standard and the safety standard is set forth in the briefs. It's very clear. It says employers are to ensure that each affected employee uses protective footwear when working in areas where there is a danger of foot injuries. There is no dispute that the hazards in this working area present a danger of foot injuries. Now, the company, as the record describes, was not fully compliant in enforcing this safety standard as to Ms. Holmes. That is not in dispute. But it's never too late for a company to take corrective action and get into full compliance. And what happened in June of 2013 is they had an outside safety auditor come in as part of the certifications that Ms. Holmes' counsel identified to come in and evaluate the safety procedures in the plant. And during that audit, they discovered that somebody, not Ms. Holmes, but another employee, was working in the shelter fabrication area and not wearing safety shoes. That triggered a write-up. And if there was another violation like that, that would result in a major infraction, and the company would be in jeopardy of losing those certifications, which are necessary to do business with the federal government, especially DOD. So in response to that discovery, they decided it's not too late to take corrective action and to get into full compliance. As the record describes, the word went out. There were meetings with the supervisors that we are not making any exceptions anymore, including with respect to Ms. Holmes, that we were going to come into full compliance. And as part of that process, they engaged in an interactive process with Ms. Holmes, trying to find alternative safety footwear that would also accommodate her particular medical situation as well as the hazards in the workplace. This was not just insisting that she wear steel-toed shoes. There were efforts, as were described, to come up with other alternatives that had composite materials that would protect her feet from serious injury. In fact, the company indicated, and it's borne out in the record, that she actually could go and come up with custom-made shoes and the company would pay for it. So while counsel for Ms. Holmes is saying there's a nuance of safety, I would argue that safety was paramount. And in fact, the EEOC has issued guidance, and it's actually addressed in one of the cases that we cited, which is the Labasio versus Broward County case, which actually involved an individual who also had diabetes, who had difficulty, who was unable to wear the steel-toed safety shoes. He took the position in the case that he should be able to wear sneakers. And the court analyzed how do you reconcile the need for honoring the OSHA mandate to protect feet from foot injuries while at the same time addressing the obligations under the ADA to deal with reasonable accommodation. And the court discussed this EEOC guidance, and in the EEOC guidance there's actually a fact pattern that's very similar to the fact pattern that's before the court. And it's discussed in footnote 6 of the opinion, but let me just, if I can, just tell you what the EEOC's guidance is. It's example 45. I'm just going to read it in full. An employer, pursuant to an OSHA regulation, requires employees to wear steel-toed boots. An employee has severe burns on his feet and legs that prevent him from wearing these types of boots. No accommodation is possible, and so he asks for an exemption. The ADA does not prevent employers from complying with other federal laws, including the Occupational Safety and Health Act, which requires employees working in certain jobs, industries, or positions to wear particular items of clothing or protective gear. Under these circumstances, the employer may insist that the employee wear steel-toe boots, and because the employee cannot comply with this rule, he is not qualified. General Dynamics did not just insist that she wear steel-toe boots. As I indicated, they tried to come up with alternatives over almost a 2-year period. During that two-year period, as the record reflects, they tried to find alternatives that would work. It wasn't simply steel-toed boots. Your Honor, with respect to the obligation to comply, the company, in fact, was trying to do a better job of it. There's no dispute about it, but it was an essential requirement of the job that this individual wear some protective footwear. The OSHA guidance that is cited in the briefs and discussed does not dictate a different result. The guidance does not say if there's a hazard, you can simply throw up your hands and just say, we're going to agree to any and all accommodations, even if the accommodation does not protect the individual's foot. In fact, the guidance talks about the interactive process, which is what the company did, in fact, do here. So from our point of view, Your Honor, there is no jury question, because compliance with this OSHA standard is not optional, it is mandatory. And while it is true that there was noncompliance with respect to Ms. Holmes for a significant period of time, as I've indicated before, it's never too late to take corrective action and get into full compliance. And finally, Your Honor, with respect to the issue of the sanctions, which I'm anticipating that counsel will address, we maintain that the district court, clearly weighed the evidence and concluded that the appropriate sanction in this particular instance was striking the late identified declarant. The omission was not substantially justified. The omission was not harmless. And as the cases say, the parties are not to engage in trial by ambush. There was an obligation on the part of counsel for Ms. Holmes to indicate, to disclose sooner with respect to the initial disclosures as well as to the interrogatory answers, that Ms. Bland was actually a fact witness that would rebut the company's statement that they were enforcing this particular OSHA safety policy. And on that, Your Honors, I will rest on our brief.
Thank you very much. Do we have a rebuttal? Counsel? Mr. Hawkins, you still there?
I am. Thank you, Your Honor. I have just a very brief rebuttal. The first thing I would do is I will refer to the case that my friend on the other side just referenced, the Labasio case. And what I would say is, What you don't have in that case is an issue of whether or not there was a past practice, which is central to our entire argument here. And it's also relevant to the issue of whether or not safety is in fact, or compliance with the safety obligation is in fact something that cannot be exempted or something that cannot be adjusted. I believe on this record, and I've looked at other cases, the parties have cited cases to the court. I have not found any case where you have more than a decade's worth of practice that all of a sudden gets upended in order to quote, strictly comply with an obligation for which the company should have been strictly complying from the very beginning. And it's not to say that you can't do that. I'm not saying that a company can never change its mind, but in this particular situation, again, as we've stated at the opening, nothing changed. Absolutely nothing changed. The audit that they focus on didn't focus on an employee like Ms. Holmes who had a medical condition. It focused on somebody who was flouting the policy and had continuously flouted the policy and didn't want to follow the policy as general as a matter of convenience. That is not the situation we have here. And we don't have a situation, as the example from counsel pointed out in the EEOC guidance with the burns, where it is a choice between not being able to perform a job and not complying with a safety procedure. We have a situation where we have a past practice that evidences, and I think this is very important, it evidences that Ms. Holmes has been safely performing this job for more than a decade. And so when you talk about safety concerns now, it falls on a little bit of a deaf ear, and I think at this point it certainly defeats the argument, at least at the summary judgment stage, that counsel is able, or that the party here should be granted judgment as a matter of law as to essential functions and as to reasonable accommodation. Following the Supreme Court's lead in Tolan v. Cotton from about 6 years ago, to paraphrase the Supreme Court, we believe that by weighing the evidence and reaching factual inferences contrary to the plaintiff's competent evidence, the court below neglected to adhere to the fundamental principle that at the summary judgment stage, reasonable inferences should be drawn in favor of the non-moving party.
Okay, Mr. Hawkins.
Yes,
Mr. Hawkins, this is Judge Keenan. Again, let's make use of the author of the opinion of the court in your favor. In writing the opinion, what are you going to say regarding why the OSHA requirement doesn't matter in this case? Why the OSHA requirement doesn't supersede all other considerations? And anything other than estoppel, because you've agreed that estoppel doesn't apply and past practices doesn't apply. What are you going to say in the opinion as to why the OSHA requirement isn't determinative here in terms of General Dynamics' right to rely on the OSHA requirement to demonstrate a business necessity, like the Bates case and the Exxon case in the other circuits? Certainly.
What I would say is that I would say that OSHA has the out, and we have cited to the court, we cited to the district court, the guidance, the interpretive guidance that says you are not required to choose between one hazard or another when it comes to PPE. The other hazard here, which is not speculative, it's not ethereal, it is a concrete hazard to Ms. Holmes to have damage done to her circulatory system, her appendages, her feet, and you've seen the pictures. What we have here is a plaintiff, an appellant who has the ability or has the hazard choice that OSHA allows. OSHA allows for this kind of a choice, one versus safety, one hazard versus another hazard. And in this, and again, it's fact specific. And
so you're saying that is the employee's choice then? Is that where you're coming down on? Sounds like it.
Well, I'm saying that you can't discount the employee's hazard in those circumstances. In this particular situation, the OSHA regulation allows for a flexible decision-making process. And I guess to respond directly to your question, Your Honor, in this particular instance and on this record, which is important, there was no question. I mean, they did a lot of interactive process about the type of shoe to be worn, but there was never any inquiry as to whether or not this regulation allowed for the flexibility that we, one, contend it does, and two, believe the facts support. And so on this record, that flexibility was never inquired into by General Dynamics, and that would have been the way to defend against a past practice of 11 years in the other direction. So with that said, Your Honors, I will rest on the briefs as to the motion to strike, and unless the court has any other questions, I would ask that the court reverse the district court and find at a minimum that material issues of disputed fact exist as to essential functions and reasonable accommodation.
Thank you. Thank you both. The case is submitted. We'll ask our clerk to adjourn court.